flash heaping themselves and forget everything. It doesn't work that way.
I think we may have covered voir dire and honest disclosure with that, and I didn't advance the slide. Can you give us a case example or an example of this?
Sure.
All right.
So
Hello.
this is an example of stealth jerk. So a case like this, you're the stealth jerk, stealth. There's a likelihood that people want to be on this case, right? It's a high-profile case. It's going to be on TV. You're going to get a lot of attention. There might be a desire to seek justice. And you want to be involved in that.
I don't know why we
How do
don't
you
have
identify jerks like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division. Rampart. And basically, there were a number of corrupt police officers who were stealing drugs out of the evidence locker, shooting suspects and planting guns on them. These rogue police officers. And one of the people, his last name was Obando, he had been shot by a police officer.
Hello, 1, 2, 3. You can hear me.
A gun on him and alleged that Obando had shot at him.
Have to figure out how.
So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of the locker room. So he confessed to all these things, and Obando was released. He got like a $20 million settlement against LA County.
This is pause. This is play.
Then he sued the public defender, claiming that they should have figured this whole thing out and known that there was a scandal and so on. And it won like $6 million in that case.
Refresh the page, see if there's something. There we go. Okay,
I've been in a movie about the incident called Gang Wars. And when they would ask, has anybody have a connection to the case? She didn't raise her hand. But during the deliberations, she talked about stuff she knew. She talked about stuff that didn't come into trial. And it resulted in a mistrial. So that's just one example. There's other examples. So that's one challenge you have in a case like that.
I see them changing.
All right.
You should have. Okay, what is going on? Okay, maybe I have to add it.
I think you're going to talk to us about how hard it is to figure out what somebody knows.
So to me, this is one of the biggest challenges in high-profile cases. So the question you ask on a juror questionnaire and open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is
there's volume, but I can't hear it.
I need to search my memory
because
and see what's accessible and salient and what I can remember on the spot. Okay. And I'll tell you. And that's and then it's usually followed up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical case.
Have you seen that bear itself out in a real case?
I have. This was a case in Texas where we actually had community members come in during the venue hearing and treated them like mock jurors in a sense and asked them what they knew about the case. And they told us. It was a big case at the time in Latah County in Texas. And people told us what they knew. And then we asked, is that everything you know? And they'd say, yes, that's it. And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, well, did you know that he allegedly confessed? And then it would stimulate a memory. And the person would say, oh, yeah, I did know that. He actually confessed twice at a monastery. So it triggered a memory. And then it was, well, is that everything else you know? Do you know anything else? And they say, no, that's it. And say, well, did you ever hear that he had committed another crime? And they say, oh yeah, that's right. He actually attacked another girl at a different church in a nearby town. And it was, well, is that everything you know? Take your time, search your memory. That's it. And then we do it again. And it was, well, did you know there was a cover up? Oh yeah, the Catholic Church covered it up and the police department, and it just demonstrated the problem. Now, that was fine in that little demonstration we did, but you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial when you don't know what they know.
Do we have a glimpse of how that works in Bryan Kohberger's case based on the search warrant?
We do.
All right. How do we know? Tell me about that.
So we always use the open-ended question. What have you seen or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items, to see if there's additional items that they actually recognized that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, what have you seen or heard about this case? Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific detail. But later when we ask those closed-ended questions, that person knew all 9 of them. Another one is just what I've read and seen on the news and newspapers. Again, knew all 9. Read articles about the case, knew 8 of the 9. Just what I read in the papers, same as everyone else, 7 of the 9. So these are just a few examples, but this is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well developed schema and attitudes and case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that had not reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognize this item when we ask, have you seen or heard it? But when we ask them the open-ended question, what have you seen or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognize it later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Bryan Kohberger allegedly stalked the victim? So that's a difficult position to be in.
Let's look at one more example of how that worked.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you seen or heard about the case? Very few people mention it. This is what you see.
All right. The magic question, can you set it aside and be fair and impartial? Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this A good question, bad question.
Will it work? Will it help
Will it
us?
work? What does work mean? I don't know what you think about that.
Help us find an impartial jury?
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders for his wife. He went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this mini-series on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, "Of course I shot them all," or "Of course I killed them all." He's talking to himself. So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, "This is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested." So if somebody said this in public about this case, I think we all agree that person probably can't be fair. You're publicly stating it to the world. You think he's a sociopath. So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we recruited said that he could not change their mind about his guilt. So almost everyone. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. That he was like a suspect in his wife's disappearance, probably not admissible in a different case. His murder trial in Texas, we asked several of these. And the confession, the captured confession, you see 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, "I cannot be fair and impartial." There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence, common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change your mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why. And so this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Durst was a sociopath. Well, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated, that's a fair and impartial juror. But it demonstrates like a person like that should be answering that question, no, but they don't. And even kind of going back to the Rideau case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that, threw out the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair, and the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
All right. Based on your years of experience, your education, all of the work that you do in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments, do you have an opinion about this case and whether we can seat an impartial jury in Latah County?
I do.
What is your opinion?
So my opinion is, again, is based on whether or not there's a reasonable likelihood of using that standard, which is less than the preponderance of the evidence. Latah County is a small venue, and the crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrate they experience fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convict, I think, given the reaction that people think the community would have if he's acquitted. That's particularly concerning. We know from the data that jurors have closely followed the case, they've talked about it, they're familiar with prejudicial details. I think that the presumption of innocence has been undermined and a presumption of guilt prevails in this community. And I think the pre-existing attitudes and opinions will influence how people process evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence. I don't know about the videos versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter of it's consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy, given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor. And Dr. Edelman, hang tight if you should state mine.
Okay, thank you, Ms. Taylor. So this would be a good time to take a break.
Sure.
And we'll come back at 3:20. Thank you. Dr. Edelman.
No.
Hey, okay, I'm just trying to see what setup is best here. Maybe like this. Yeah, like that. So, what are you thinking? What do you think? What do you think the judge is going to decide? Do you think he's going to decide it today? He rarely does. Judge is extremely cautious. He has a lot of pressure on him, and people don't understand that. He he has a lot of people to consult with to make sure he's doing everything the way it should be done so that no appeal, like there's no loopholes for the defense to grab onto, to use, to whatever. They're very aggressive, that defense team, and he needs to make sure that everything is done right, so they can't come back and throw away anything that was done. And I understand his caution. This is a very important case. I think he's a very thoughtful person. And I also think that there is something going on here. There's a reason why everything is being stalled and taken very slowly, because we have a lot of top secrets in this case. And I'm one of them. Let me introduce myself here. My name is Claire Elliott. I'm just trying to find my way around here. I'm the founder of the Department of Empowerment, and I founded it in 2001 upon the campus of SoCo University of America in not Calabasas. What am I thinking? And Aliso Viejo. It's been a while, okay? Forgive me. Anyway, I'm here in Augusta, Georgia now, and this is my first live stream on this channel. And after a long break, I was operating a different channel. I want to say the Dragon King's daughter, because that's who he really was. But I think that most people would understand what I'm talking about when I say I am the Zodiac killer's daughter. And I recently responded to, I guess his name is Jay Foy. I don't know what his first name is right now. Is it Jeremy? I don't know. He started a YouTube channel and got like over 700 subscribers. It's probably up to, I'm not going to go to his channel to, I don't want to give him any more attention than he already has. He has like almost he's getting close to 1,000 subscribers. He could just start making videos. I mean, he hasn't made one video yet, and he already has almost 1,000 subscribers. So he could be monetized from day one. I mean, well, he has to have a certain amount of watch hours, 40,000, right? And if you don't have any content on your channel, you can't get those 40,000 views. But I'm sure it would be easy with 1,000 subscribers. I mean, you have to have 1,000 subscribers. Yeah, I've always struggled with my consistency, and so I'm gonna change that now. And I'm really committed to the truth heals. I feel like that is really the essence of who I am, and that's what I want to focus on, because people think, oh, everybody comes forward with all this shocking kind of shocking stories. Yeah, my life has been a real shock. My life has been so traumatic, like the most traumatic I have ever heard or known. I have never known anyone with a more traumatic life than me, and lived to tell about it. Okay, I shouldn't be alive, but I am. And why am I alive? Because I am meant to tell my story, and one day everyone will listen to me and have no doubt about what I'm talking about. Okay. One day soon, the FBI will be backing me up and confirming everything. One day soon, the FBI will introduce me to the world. I've lived in the shadows, behind the scenes, and non-existence for long enough, and I'm so tired of it. And I'm 58. I'm almost 59. My birthday's almost here, and I'm almost 59. I mean, I am pushing 60. I am a senior citizen, kind of, right? Bojangles doesn't always think so, depending on who's working. But I think, I know at IHOP 55, you're a senior, and I reached that milestone 4 years ago, almost. A little close to 4 years ago. So Anyway, I'm really looking forward to having, if I didn't get to have a good life as a baby, I I was sketched as the Gerber baby, and thus my logo. When I was just 6 months, I had just started speaking clearly in my first language of Japanese. I was the artist. Was a very young Gary Murray. Long before he was ever a Buddhist who was a member of the SGI, and he's a big leader over there now. Has been heading their arts um, and of course he's part of the LGBTQ. Did I get that right? Community. Anyway, and he sketched me again as the copper tone girl when I was 2 years old. I was celebrating I was given a puppy for my second birthday. Her name was Curry, and she was a black sheepdog poodle mix, not a cocker spaniel. And but Daddy, and I refer to Daddy as he's the man who raised me, who was there when I was born, who I owe everything to my life to. I owe my life to him. And he's a guy named Clint Eastwood. He's British, but he pretends he's an American cowboy. And I have no contact with him. He was removed from my life when I was, I guess, 5, turning 6. My family left California and I think it was in June of 1971 when I was 5, and I was turning 6 that October. And that he has never been allowed back in my life since. There was a contract signed by my father, who I grew up with, Dennis Wayne Elliott, who is the Zodiac killer, and Daddy. He was never allowed to have any contact with me again. And basically the contract was it took me a while to remember this. This is very recent. This surfaced over the course of the last, I think, 3 months or so. I'm not exactly sure of the timing, but in the last 3+ months, I have finally remembered that my father, the Zodiac killer, signed a contract with our government that said that they would protect his identity and keep him top secret in exchange for him paying me, a little baby or a little girl at the time, a certain percentage of all his income. And I don't know what that percentage is, but it might have been 80% for all I know. And I guess he had made a lot of money. And I mean, I have no contact with any of my family for that matter, but I have no contact with Daddy. I have no contact with that money. I have not seen one penny of it, but apparently my accounts are full of, the money my father, the Zodiac killer, agreed to pay me, in exchange for the government protecting him and not getting caught for the rest of his life. He was going to die in his infamy, a legend in his own time who was never captured. And that is the fantasy of all serial killers. It is. And he achieved it. And boy, there's nobody more of a classic serial killer than the Zodiac, as a lot of people call him. Anyway, I guess the hearing is about to come back in about 5 minutes. I'm gonna put that on the screen in a minute, but I just wanted to kind of give you a little of my backstory. On this channel, I'm gonna be live streaming a lot because it's too hard for me to be consistent when I have to edit and everything. Of course, I have more time now because I used to be like a 24/7 caregiver, and she recently passed away in April. Her name was Elizabeth, and I'm here in the room she used to stay in when she lived with me. I took care of her for 5.5 years, and so I have a lot more time on I can't really say I have a lot more time. I still have a lot of business to finish up. Dean, my husband, was the executor of her estate, and I'm this excessive executrix, I guess you would call me, and and then we've had like we've had more, but more than this. There have been more people in our life who have died, but 3 significant family members have died in the span of like 9 months in our family, and it's just been overwhelming. And 2 of them were violent murders, and by a family member, no less. Very traumatic. So I'm managing all the paperwork. This is I always we I had we had a guardianship with Elizabeth and a conservatorship. There was always a lot of paperwork, and because I was taking care of her 24/7, it was really hard to keep up with everything. It really was the job of, like, I think altogether what I was doing all by my lonesome was the job of, like, I would say like 8 people, something like that. Different shifts and somebody managing everything. I just took care of her entire existence and appointments, paperwork. I just ran her life, and she ran out of money and wasn't able to pay us. My husband also, helped a little bit. I did like 99% of the work. And, she owes us her estate owes us tens of thousands of dollars, which we'll never see the day, we'll never see it. Anyway, so I do have a little more time on my hands. I've been trying to get organized and get this together because it's always been my dream to be successful here on YouTube. It's always been my dream. And I've just never been able to commit the kind of time to it. I've never had the confidence. I've never had everything that I've needed. I struggled learning everything over the year, and if you're not consistent, it's always a learning curve. There's always more to learn. But we're getting there. And yeah, I think this is the year. Okay. So I wonder, something really exciting is going to happen today. I just know it. Here in the Bryan Kohberger trial I'm talking about. And let's kind of look at there we go. Let's look. They're going to be coming back any moment. They're due back right now. And I wonder what they have up their sleeves in Idaho. I think something's happening today. To be honest, I really think, I've been dreaming of the moment when Bryan tears off his mask, because he's not really Bryan Kohberger. He's another serial killer who was in my life and who is the genetic son, the genetic son of Dennis Wayne Elliott, who was the Zodiac killer, my father. And his name is Dean. My husband's name is Dean Wayne Boyd, and his twin brother is Dennis Allen Boyd. The Zodiac killer, my father, was Dennis Wayne Elliott, and the serial killer who is the true identity of Bryan Kohberger is David Wayne Craig. Yeah, all related. Everybody's related. Okay. I always say that my husband, Dean, has the rage of a serial killer, but he has the heart that shuts it down. He would never kill anyone unless he was defending me or somebody else, some vulnerable person. Yeah, he would not hesitate to kill somebody who was trying to kill somebody, an innocent bystander, or me, or he wants to kill all my abusers in my past, and that's why we have him on medication so he doesn't do that. But yeah, he's he's got a heart. That's what serial killers can't be serial killers unless if their heart rules them. They can't. David Wayne Craig usually has to take drugs to shut down his heart and do the dirty deed. Otherwise, he has a heart, and I've seen it. He has compassion. He has empathy. I wouldn't have ever gotten involved with him and been in a relationship for so long if he hadn't. But he knows how to bypass his heart. I'm not able to do that, you know, thank goodness. That's my great fortune. But some people are able to do that. And I think men in particular are able to do that more than women, because you have, you know, men have more of a separation between the two hemispheres of the brain, which makes it a little easier to shut down the emotions. But that's not healthy. And sometimes this is what happens. You create a monster, which is a serial killer. Anyway, David is not 29 years old, isn't? Yeah, Bryan Kohberger is supposed to turn 30 in November, right? David is 70 years old. He's a very youthful 70. Okay, he's always looked like 20 years younger than he really is. He's, you know, his hair must be very, very long underneath that mask. And I really, I would be so thrilled if, they're coming back. I would be so thrilled if he like takes off everything and we see his long blonde hair. I mean, it's probably a little grayish by now. I haven't seen him for years, but wouldn't that be exciting? Okay, here we go.
It's all Steve already. All right, so we're now back on the record. This is State versus Kohberger, case number CR 29222805. Kohberger is still in the courtroom along with counsel and also counsel for the state. And Mr. Edelman is ready for cross-examination, I believe, and you're still under oath. So go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Oh, okay. May this witness be excused.
You may, Your Honor.
Okay, thank you. You're free to stay, free to leave. Thank you. Appreciate for you being here. Okay, another witness.
Yes, Your Honor. Our last witness is Dr. Dare.
Dare. Okay, I thought maybe Dr. Dare was going to be rebuttal to the state. No.
Your Honor, we disclosed Dr. Dare twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony. Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but we ask that she stay for that if that's the case.
Okay. So Dr. Dare, line it up. Please face clerk, raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes.
Thank you, ma'am. Please have a seat, and then once you're seated, please state your name and spell your last.
Yes, Veronica Dare, D-A-H-I-R.
Thank you. Ms. Taylor. Go ahead.
Thank you, Judge. Good afternoon. All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno. I'm also the director of survey operations for the Nevada Center for Surveys, Evaluation, and Statistics, also at the University of Nevada, Reno.
Do you also do consultations outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
I have a bachelor's degree in psychology and a master's and PhD in interdisciplinary social psychology from the University of Nevada, Reno. My master's and PhD are from the University of Nevada, Reno. In terms of my work at the university, I have a joint appointment, as I mentioned. I run two different research centers at the university. One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is a survey lab. I also teach in the Judicial Studies program. I teach a graduate level course called Scientific Research Methods for Judges, which is a course for judges getting their PhD across the nation. They're sitting judges that are on the bench. I teach another course called Scientific Methods for the Justice Management program, which is a master's degree program at the university. I have taught social psychology, criminal justice research methods. I've taught other courses, but that was quite a while ago. Right now, I'm just teaching this graduate level course. I serve on several dissertation committees for various departments on campus: social psychology, psychology, School of Public Health, computer science, natural sciences. There's many. I serve as a dissertation advisor and committee member for students that are getting their degrees, and primarily in the Judicial Studies program, I have served as an advisor and as well as the social psychology program on campus. In terms of my role on campus, I do primarily, let's take the Sawyer Center first. We do research on justice-related topics broadly defined. My background is social psychology with an emphasis in justice studies and law. And so our research that we've been doing there is specifically related to research in the justice system. We have many different populations that we research and do surveys with, including jurors, judges, attorneys, both defense and prosecution, court reporters. We've done many surveys on diverse populations as well, including people experiencing homelessness, LGBTQIA populations, the elderly, prisoners, inmates, Native American populations. So we've done many, many surveys in that capacity. In my role as the survey director for the Center for Surveys, Evaluation, Statistics, I am in charge of multiple research projects that have to do with surveys nationally, regionally, and locally. Most predominantly, the one that we have been doing since I've been there in 2006 is the Center for Disease Control and Prevention, otherwise known as the CDC, their BRFSS survey, which stands for Behavioral Risk Factor Surveillance System. I am the project coordinator for Nevada, and I've been doing that role since 2000 for the state of Nevada for the last 3 years. But before that, I was the data collection supervisor for this project since 2006. So I've been working on that project for quite a while. Prior to my role in both of these programs, I also worked on surveys. I've been doing, I would say, surveys and research for almost 30 years, since I've been a graduate student, and even before that. So not before graduate student, well, I did research, but before my role in this area, I did research. Most predominantly for the Sawyer Center, we did a nationwide survey on Daubert, and it entailed 400 randomly sampled judges across the nation. And we looked at the effect of Daubert on judicial decision-making. In both of my roles, I work with many organizations to do surveys. We do work for, besides the CDC that I mentioned, many state agencies, Nevada Department of Transportation, Department of Training and Department of Employment, Training and Rehabilitation. I won't do all the acronyms. I won't do that to you, so because I can shoot off all the acronyms. But we work with the National Judicial College. They're right on campus. I'm in the building actually. National Council of Juvenile and Family Court Judges. We've worked on projects with the Federal Judicial Center, the State Justice Institute, and many more organizations. I know you're going to ask me other questions, but I wanted to get those out. So
I do have a couple of questions for you. You said 30 years about of your life you've spent doing this work.
yes,
And it sounds like it has a whole lot to do with survey work.
yes,
Is that both designing surveys and then critiquing surveys?
yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals. I personally have published on different aspects of survey research in Judicature, Justice System Journal, Future of Evidence by the American Bar Association. I have a chapter in there. That one's not specific to surveys, sorry. I have other publications, but specific to surveys, Survey Practice Journal, Law and Human Behavior on the judge survey that we had done. There are numerous. I don't know if I can remember them all right now, but in terms of technical reports, we do a lot of technical reports for our projects. And those are basically reports of findings that we give to our clients specifically to use for their organizations based on whatever topic it is that they want us to survey or, study. So I mentioned some of them before. We DETR, which is Department of Employment, Training and Rehabilitation, Nevada Department of Transportation, Nevada Department of Corrections. I don't think I mentioned that one. And we've done 140 over my career there, 140 technical reports, all of which in some way or fashion have related to surveys or survey research. We do a lot of evaluation projects, needs assessments, and most of those always entail a survey of some kind.
Are there guidelines or standards that govern survey work?
Yes, ones that have been mentioned here already. APOR, the American Association of Public Opinion Research, and specifically for change of venue surveys or community attitude surveys, ASTC, which is the American Society of Trial Consulting.
Are you familiar with the standards of both?
Yes, I'm a member of both organizations.
I want to know why people do surveys. It sounds like you've had a hand in a lot of surveys over the years. Why do people do surveys?
Many different reasons to find out information about a specific topic or population. People do it for needs assessments. They do it to find out more about support services. If they want to increase support services in their organization, or if they want to just find out an evaluation of what their program is, if they receive funding from a government organization or a grant to do a specific project, they want it evaluated, and that usually entails surveys. People want to know community attitudes. For example, as I mentioned, a couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not what their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision-making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing research. You guys have been asked to take many surveys about projects that not projects, but things you bought, things that, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have been bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of surveys that reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization. And in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information. And that's in order to make a decision.
Yes, decision making, and especially within their organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to the legislature for whoever our clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call Assembly Bill 122 in Nevada, where they were looking at the assisted living communities within the entire state of Nevada to see if there should be change in those areas. So those are some examples. And primarily, like, I guess a good example would be the behavioral health, BRFSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes. So we ask questions like behavioral risk that's related to how many fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practices, substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Yes, I mentioned a couple of the examples that we have done community attitudes on. And that's basically measuring attitudes of the community on a specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted relating to venue issues?
Yes, I did. Excuse me. I forgot. I have these.
Okay.
Exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
Okay. And I can see you just place those face down. If you need to place them back face up, will you let me know?
Yeah, I will. Sorry. What was can you repeat the question?
That's okay. I'm wondering if you had an opportunity to review the survey work done and conducted by Dr. Bryan Kohberger.
Yes, I have.
Okay. And do you have an opinion about whether that survey was conducted in a valid way?
Yes, I do.
What is your?
In my opinion, it was a valid survey.
What do you base that opinion on?
So there are standards and professional code of ethics that I mentioned earlier, suggested by AAPOR, again, AAPOR, American Association of Public Opinion Research, and the American Society of Trial Consulting, ASTC. And specifically, ASTC has a section on venue change surveys. And there are many things that can go into a survey to determine its validity and reliability. I guess I should talk about that before I go into that. When you're talking about scientific reliability, by the way, it's very different than evidentiary reliability. So evidentiary reliability is looking at the trustworthiness of evidence, whereas scientific reliability is looking at the consistency and repetition of a survey done over time, across different populations. And validity is more looking at trustworthiness or accuracy. So if we talk about reliability as consistency and stability of results, and validity as accuracy, that's how I'm going to talk about those things. And with respect specifically to this survey, there are many types of validity and many types of reliability, but I'm not going to go into all of them here. I think specifically for this survey, what's important is content validity, construct validity, measurement reliability, and response reliability, specifically with this survey, and looking at coverage error and what we would call external validity. There are other types, as I mentioned. There's criterion validity, there's inter-rater reliability, test-retest reliability, convergent validity. There's many types of validity, but I'm not going to talk about those here. I'm just going to talk about the things that made me come to my opinion or form my opinion based on the survey. according to the ASTC standards, when you're doing a change of venue or community attitude survey to look at whether or not a change of venue should be conducted, or a change of venue might be considered, you want to look at 6 things. You have screener questions, you have case recognition questions, you have questions related to the source or the media where the information comes from, you have demographic information, and then case knowledge questions. I think I got them all. And that's what I was looking at with respect to the content. And those were all there in Dr. Edelman's survey. The other thing I looked at was the questions themselves. Do they have what we would call construct validity, which is basically, does the survey measure what it purports to measure? And then does it have content validity? Does it cover all those things? And it does. I mentioned that already. That's the content validity, those 6 items. And was it done in a way that you can consider it? The measurement was reliable, and I would say yes. I read the methodology was brief, but based on what I could gather from the report that Research Strategies did, they did all of the things that we would have done. I would have probably done a little bit more in terms of looking at, some of the disposition codes were just a little bit hard to determine, but that's not that important for this. What I would say is that they did everything we do in our lab. We are very strict, I would say strict when it comes to our methodology for our surveys, because we follow APOR, which is the strictest standards that you could follow for calling on a telephone survey, or what we call an RDD survey, random digit dialing. And primarily that's because we have to do the CDC survey, and the CDC survey follows the APOR guidelines. And so for all of our projects, whether it's BRFSS, whether it's CDC or not, we follow the same protocol. So no matter what project we do, whether it be for NDOT or DETR or any of these other organizations that I mentioned, we would definitely follow the same protocol procedures. And that includes things like good questionnaire construction and design. That's the first thing. In order to combat what we would call non-response bias, the first thing you look at is questionnaire design. Are the questions written in a way that would get the responses that you need? Do they have content validity? Are the questions valid? And by that, I mean, we look at things like question order. We look at the whether they're leading, whether they're loaded, whether they're double barreled, whether there's many, many things we look at. So I looked at that. And then we also look at how the survey was sampled. And according to Research Strategies, they did use a random digit sampling frame. And by that, that means they probably, I don't have all the details. I'm just going based on my opinion, my experience. What we do for our surveys is we order our sample from the sampling company, and we get replicates of phone numbers. And what that means is we get them in blocks of like 30, for example, and you would call your replicates of 30 phone numbers until completion. And that's to make sure that you are not biasing your sample. So you don't want to call, here's an example. If you get 20,000 phone numbers, you don't want to call all 20,000 phone numbers just once. That's not how it works, because you're only getting those people that answer the phone on the first ring. So that's biasing. Also, you're reducing your response rate by doing that. So what we do is we call them in blocks of numbers, and we call them several times. From my understanding, they called them 4 times. Research Strategies is they called once. If they didn't get a hold of them, they called 3 more times. They did callbacks. That's also proper protocol. We like to call our surveys at least 3 times during 3 different time periods, either the morning, afternoon, and evening. We also like to call them during the day and on the weekends. My survey lab that I run is open 7 days a week, and every single holiday except for Christmas, Thanksgiving, and believe it or not, Super Bowl Sunday. It's the other American holiday, apparently. Anyway, people get mad when you call them on Super Bowl Sunday versus Father's Day, Mother's Day, and Easter, believe it or not. But anyway, so we call these numbers at different times. And from what I could tell, they did follow-ups, they did different call timing, they did callbacks, they did the replicates, they used both cell phone and landline. It is customary practice now when you're looking at coverage validity, you want to get more you want to make sure you're getting the population that you're interested in. And now so many people have cell phones. So in our lab and most labs across the country now, we do like 90% cell phones versus 10% landline. Now it's customary because of the reduction in the number of people that have landlines. Anyway, those are some of the things that I looked at, and whether the questions themselves, like I said, were valid in terms of what they were being asked.
It sounds like
Did I answer the questions?
you had a really
Okay.
thorough look
Okay.
Before you had your opinion as to whether the survey was valid.
Yes.
Do you have an opinion about whether it was reliable?
Yes, in terms of measurement reliability, which includes things like if you are an interviewer and you are asking questions, it could be biasing if you're not trained properly. And the mode of survey that you're doing for change of venue surveys, the typical mode is RDD surveys, which is phone surveys versus paper or in person. And so the interviewers must be trained and supervised. My understanding is that research strategy has been around for 20 plus years. So I'm assuming they're like our lab where they were trained properly and they have supervision where there's supervisors also supervising the interviewers. So that's another way to combat non-response bias, which includes refusal conversion training, which is, I think Dr. Edelman alluded to it earlier, things like soft refusals. If someone calls up and says, I'm making dinner, I'm too busy, I'm giving my kids a bath, I'm running to the store, whatever it is. We train the interviewers on how to handle those situations so that we don't get only the first person that answers the phone or only those people that are saying that they're busy. So that's all part of the training to make sure that we get at non-response.
Right. I think that you have answered my questions really well, based on, just to sum it up, based on your look at the work done by Dr. Edelman with this survey. Your opinion is that it's a valid survey.
Yes, basically it's what I would have done or what we would have done in our survey lab.
Thank you. I don't have any other questions right now, but hang on and ask Peter. Okay, thank you.
Thank you.
We have no questions for this witness, Your Honor.
Okay, great. Thank you. Is it
Nobody that easy.
so easy? So
Thank you.
witness be released.
She may, Your Honor.
Okay. Thank you for being here. It's very interesting. Help yourself, yeah, as much as you need.
Thank you.
Thanks. All right,
Fit for witnesses, Your Honor.
no more witnesses. Okay, any witnesses?
None from the state, Your Honor.
Okay, we prepared for argument?
Let's do it.
Okay, go ahead.
Thank you, Your Honor. Your Honor, the decision to change venue rests on what you've heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is a huge amount of coverage. The kind of coverage is prejudicial coverage, and it's had an impact on the Latah County potential juror. The court can see actual prejudice by understanding the results of that survey. Reading the hundreds of comments from Latah County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Latah County. The court can also presume prejudice by looking at this case as it is. It's an extreme case that comes out of the Haddon case in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Latah County, it's bigger, it's a state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written, primetime television shows have happened in this case. It just doesn't stop. And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items. At least some of them. This is all before the other things contained in the media are subject to admissibility rules, even if they're offered. Subject to cross-examination and full context explanation of what they mean. So you have this coverage that permeates the community. Bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming. That doesn't take care of all of it though. The live stream is captured and replayed almost in real time, if not real time. Everything that happens in this case is on social media, and all kinds of things that don't happen in this case run rampant in news stories, in social media stories, and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helped train. It's all negative. It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there. When you have this much information surrounding a case, it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by Crusoe this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County is. So that's a lot of coverage directed into Latah County. And that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing misinformation. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. You understand that, we understand that learning from Dr. L. O'Leary this morning, when she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudgment of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away. You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a scheduling order a couple of months ago. And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings. And that's a lot of media coverage, and people in Latah County are going to see it and read it, and they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition, and there's prejudgment in Idaho, but there's hope. When you look at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good, because that links right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in this state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller. Imagine with me that we are here in June of 2025, and we're here and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. You can't be sure that there's a way to pick an impartial jury in this community. In Ada County, we don't have that. We don't have Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. There are people who don't have those connections. The other difference that I think is really important to think about too is the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider, but in the community about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the courtroom. People in Ada County do not have. And why Ada? Why not Canyon or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to Bannock County, I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem. So that's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Latah. Canyon County is the second largest. And Your Honor, honestly, if the court says, let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through the media. They would be kept private and in secret and secure. It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures. And the right to a fair trial cannot happen in Latah County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue needs to be changed.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor. Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Latah County, Ada County had significantly more coverage than Latah County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor, I'd like to talk about what the numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit F1, Dr. Dare. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with 400 survey respondents in a population within the range of our population in Latah County and in the population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County, 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon, 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County, 29%, Ada County, 25%, Canyon County, 23%, and Bannock County, 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing, as we approach trial, to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it. I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete. When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do. We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000, as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? 19% said no, 16% said no opinion. You add those up and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger? No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Canyon County. And frankly, Your Honor, as we move toward the issue of convenience, if anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more convenient options closer to Latah County. Either Kootenai County or Nez Perce County would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, student or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it. But if the court were persuaded that a Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County. Lewiston is approximately 30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that. Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County courthouse, in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion. The reason Ada County does a good job of that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they can accomplish that with careful planning and preparation over the many months between now and trial. It is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, council referenced the cost of transportation to and from the airport and correctly noted that the Spokane airport is considerably further from the Latah County courthouse than the Boise airport is from the Ada County courthouse. That's absolutely correct. However, the Lewiston airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also the logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth. I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, a larger side, on the larger side for counties within this state, that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty. Ms. Taylor?
Thank you, Judge. Governor, as I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood that it impacts the impartiality of the jury, that it impacts Mr. Kohberger from getting a fair trial? Don't think about county's numbers. Don't think about Canyon County's numbers, and don't think about Bannock County's numbers. Think about Latah County's numbers. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County. You know, the jurors have been exposed to prejudicial media. You know that there's been an impact on you. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot. The court then has to decide, what do we do? But answer the first question first. Answer the first question first. And don't be tempted to say, well, maybe we could go to Kootenai County, maybe we could go to Nez Perce County. We don't have any surveys on them. We don't have any information on them, except we know that Dr. Edelman pulled a couple hundred stories from the Lewiston Tribune and looking at the local media coverage because of the closeness of Moscow and Lewiston. And except that we know that people in Lewiston have the same nightly news as those in Moscow. And by the way, so does Kootenai County. KXLY that broadcasts all the stories on their nightly news, that happens at my house, it happens at Mr. Thompson's house, and it happens to somebody who's from Lewiston too. That's the same news. The difference is the newspapers, and the difference is the community connection and what that means in this case. So don't be tempted to go to another county we haven't surveyed. We've surveyed a lot of comparative counties. Stay in the place where your decision rests on what's going on here in Latah County. For sure, when we do get to jury trial, you should do individual report. For sure, we should do a jury questionnaire, and we should talk amongst all of us and try to figure out if we can excuse some jurors before they're ever brought in. They should never be on camera. We should try to keep them as anonymous as we can. Those are all things that we absolutely must do.
I agree with that.
To be the very most protective, you have to answer the first question. And that question is, we have to get this case out of Latah County. That's an important decision, and it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts plan. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first. And then think about where it's most reasonable to have the trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here. There is no way Mr. Kohberger can get a fair and impartial jury.
Well, I'm not going to give you a decision now. Number one, I would say this is probably professionally the most difficult decision I've ever had to make. Both sides, okay, have made really solid positions and supported that. I know there are a lot of considerations, practical, in terms of logistics and prejudicial media. So I have some work to do. I'm going to go through everything. Okay, even if I got most of everything, but that's going to take me a little bit of time. And go through go through the law again, too, including the rule itself and the interpretation of that. So, I'll do my best. It's a challenge. So that's probably all I should say at this point. But I listened carefully all day, and I thought there was some really important things to think about, both sides, and that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
I don't know how to do that. Okay. I don't know how to do this. Okay. How do I do this? Add to the stage. Why is this not doing this? Oh. I'm sorry. I am just really like trying to figure everything out. Anyway, I hope you enjoyed the live stream. I knew Judge was I knew he was gonna do what he did. I knew he was gonna wait until another time to make a decision. He's a very cautious guy. And I think that is wise. I could go either way. But I guess, you know, I do lean towards the defense on this one. And I don't like that I lean towards the defense. You know, I'm not on the I know, I have my own, I mean, it's no secret that I know that he's guilty. So, I mean, for myself, I know that everybody is innocent until proven guilty in this country. And, but yeah, I agree with the defense that it is a close-knit community, not the smallest town in Idaho, but very close-knit, and people have very deep emotions about this. Their whole town was turned upside down, and the media coverage has been relentless. I think it would be a good idea if we don't want some kind of problem later with I don't know. We don't want we don't want the defense to cause any problems later, and I think it would be wise to move it, even if it's going to be more expensive for a lot of people, a lot less convenient. I think it'd be good to move it. It's not just all about the numbers. Anyway, thank you for joining me on this first live stream of the channel. I plan to do a lot of live streaming around here because editing takes a lot of time. And live streaming is just such a natural thing. And anyway, I look forward to telling so many more stories in my life. I look forward to seeing how the Bryan Kohberger case develops. I'm very excited that we're getting closer and closer to a resolution. Nothing too out of the ordinary happened at this court case today. I was really thinking they had some kind of surprise up their sleeve, and maybe they did, but it was off camera. You know, after lunch, there was like 10 or so minutes that they would not allow the cameras on. We don't know what happened off the cameras, out of the way of the cameras. The victims' families know. They were there. They were involved. The court wanted to involve them. Apparently, it was some kind of brand new evidence that emerged. so serious and so shocking that the cameras couldn't be on. At least that's how they deemed it. Interesting. I really hope to hear more about that. I'm really looking forward to new developments very soon. I really think we're on the verge of something big. All right. Thank you again. I'm going to let you go to your life, back to your life, and I'll see you soon, okay? Thank you. And I'm going to be struggling here, but I just want to show you my outro. Okay, bye-bye.